Good afternoon, everyone. Thank you for joining us for today's seminar. I'm Kathryn. I'm joined by Boughman, and our topic today, as Tony mentioned, is social media and ethics for healthcare businesses. We've got a lot of material to cover today, so we'll just go ahead and jump right into it. A high-level overview of what we're going to be talking about today is we'll give an introduction, business use of social media, part 3 here, healthcare ethics and social media. That's kind of the bulk of our content in today's presentation, advertising and promotions, and we'll have a few minutes towards the end for questions and wrap-up comments. So what are we talking about? I think everyone's pretty familiar with various social media outlets. I think pertinent to the healthcare space is review websites. We'll touch more on that later on, how to combat potentially negative reviews and what to say if there's a negative posting regarding your healthcare business.
And a note, Kathryn, that there's a study, I think it was CMS issued a study or report that suggests that upwards of 60% of people looking for new healthcare providers review online reviews. So it can be very important.
I think just like anything else, you're looking for a little background and someone who's gone to that provider and may have some firsthand experiences. How healthcare companies use social media. I think the right-hand column here is specifically the things that we want to call out in the healthcare space. Disease self-management tools, monitoring and health tracking. For instance, if anybody uses Fitbit or some of these fitness apps, there's forums on there for people to share statistics or weight loss goals or anything health related. Second bullet here, recruiting patients for clinical studies. That's pretty interesting because I think you can learn a lot from somebody on their social media profile, including what they may or may not be, dealing with health-wise, and that may be a source for clinical studies administrators to review and comb through to find potential patients and candidates. And third, patient empowerment. We were talking prior to going on the air, and there's a lot of correlation between, if it's cold and flu season, there may be a lot of inquiries out there about flu remedies or homeopathic or other types of questions that people post to one another. So these types of forums and discussion boards are frequently utilized for people who are doing their self-research.
Yeah, I think it's interesting to note about essentially like a groupthink, or when people are making comments for alternative remedies, you see a lot of discussion boards and so forth for non-medical alternative type remedies. Right. But you also see it for people who are dealing with unique medical situations. And in fact, there's health organizations such as Mayo and some other websites that actually keep an ongoing discussion board for medical issues.
So some of the risks associated with social media use, again, a lot of these platforms have character limitations and people use informal language. So there may be, a message may not be coming across as intended. That's always a risk, no matter what industry we're talking about. We'll talk a little bit more about potentially deceptive advertising when there isn't a disclosure of certain connections an endorser may have to a business. IP rights, privacy and security, will hit on that pretty heavily later, and how HIPAA and PHI restrictions should be minded whenever you're using social media in the context of your healthcare business. And obviously, you don't want to disclose confidential or proprietary business information.
And we're going to focus a lot on the PHI in particular. Protected health information is very broadly defined, and responding on message boards, communicating with patients, you can run afoul of releasing certain PHI unintentionally. So we'll show you what to look out for there.
Some practical tips and good practices when you are using social media to promote your healthcare business. One, have policies in place, communicate them to your staff, make sure whoever is posting on behalf of the company social media accounts gets the necessary approvals from management to create posts or content. There should be a policy on how to address inquiries. We'll talk about this a little bit later, but I think one of the key takeaways is if something flames up on a social media site, do your best to take it offline and deal with the issue directly with the person who may have an issue or concern. Again, you want whoever is speaking on behalf of your company to do it in a knowledgeable manner and without any kind of misleading communication, whether it's omission or affirmative statement that could be misleading. And then again, if you're using endorsers or people to help promote your services or products, make sure that their connection with the company is disclosed.
And with all businesses online, and particularly healthcare businesses like we're talking about today, when you get past the privacy and security issues, which are always a concern, the next biggest issue that we see, because it's still a lot of wild west type area of law, where we don't have specific statutes, you are always under an obligation to not be misleading, either information that you provide or information you will omit to provide, such as discussing something in a promotional type tone, such as great results from a particular provider, braces, plastic surgery, something of that sort, without disclosing your connection, either that you're being paid or that you're an employee of the business. And that's what gets businesses in trouble most of the time. It's just by omitting information that's important.
So what happens, I guess, if there's a debate that is on social media about your business? You're typically, you want to combat that with facts, factual statements that make your point. The more you get into opinion or commentary, you have a risk that there could be issues down the road from that. There may be far worse than the issues that you're trying to combat on social media. Sometimes you just ignoring is the best thing, is just let it die down on its own. If there is a mistake, a mistaken post or something on your social media pages that are done in error, quickly correct it and be transparent about the correction. Just again, try to maintain just clarity as far as factual correctness and who's posting on behalf of the company.
Yeah, I think oftentimes the gut reaction is to respond quickly to comments on social media, but often the best approach is to take it slow and decide, first of all, what's going to be accomplished by another reply or response. Sometimes you're better off not to respond at all, or again, just a simple response, try and take the dispute offline. And whenever you get into competition issues, if you're not making statements of fact about your competitor, you're going to expose yourself to potential liability. So keep that in mind. At the end, we have a hypothetical on that. Not all the time, but you got to be very careful when you're making competitive analysis or competitive comparisons, that you're only stating facts.
In a few slides down, we'll have some actual language that I actually think are good things to think about and maybe implement in a response plan. So ethics, business use of social media and business policy. Any business, including a healthcare business especially, should have a code of conduct and ethics that formally, or training that helps employees understand what they can and can't do. Here's a list of typical issues that we'd like to see addressed in the code of ethics, and we'll talk more about privacy and confidentiality in the PHI context a little bit later on.
That's right, and we provide also there'll be some additional information you can include in either a social media policy if you choose to adopt one, or that you can have an acceptable use policy with respect to social media and online activity. But one of the big ones here that's bolded, and this is especially for healthcare providers, doctors, the AMA has some guidelines that strongly suggest that you need to keep your personal and business commentary separate. Obviously, so that people, if they see somebody who's a licensed physician making comments, you want to make sure that your personal comments are distinct from professional comments and the two don't get confused.
So one of the things that the policy needs to be designed to do is to protect your patients, vendors, business associates, and other stakeholders of the business. Obviously, you don't want to refer to patients or particular cases by name, reveal any PHI or confidential information. And as Eric mentioned earlier, PHI is very broadly defined. Something that you may not think of as PHI could be if you connected all the little dots, and people can kind of amalgamate the disclosures and figure out who the disclosures specifically pertain to. You don't want to go online discussing things in a forum. It's best certain sensitive items you want to discuss offline directly. And again, things that are hashtags or maybe something meant to be encouraging could inadvertently give away PHI. You want to be careful how specifically you use hashtags and names.
If anybody's ever gone through the process or is familiar with how you anonymize PHI, there are 18 different categories of information that need to be removed for anonymization, or you have to have an expert sign off. So again, just better to keep things plain vanilla when you're talking about healthcare business operations, whenever you're referring to a client or a patient online.
Another potential issue that's created with social media is disclosure of confidential information and intellectual property. It may not be specific to a patient, but it may be something that's valuable information that has to do with the business. So one of the things that we wanted to mention here is if there is a disclosure or infringement, make sure you take prompt action to fix that. Legally, the longer you wait, you could be saddled with an argument that you somehow waived or didn't take an aggressive position early on, and that could compromise your legal strategy down the road.
Yeah, oftentimes moving for a remedy, trying to get a remedy for somebody using your intellectual property improperly is to seek an injunctive remedy, injunctive relief from the courts. And if you wait a while, one of the elements to get an injunction is to show irreparable harm. So if you have what is really non-repairable harm to your business from the release of this information, but you wait 3 months, 6 months, a year, and you decide not to do anything about it, it looks like you're treating it like there's no real harm and there's no irreparable harm, and that's how a court's going to respond. So you need to act fast.
Also wanted to remind everybody that social media accounts are a business asset, just like any other asset. You're going to want to protect them and secure them. As a business asset, that may be part of an acquisition strategy later on if you want to sell your business and you've got a lot of followers or a big social media presence. That could be something that is attractive to a buyer. So make sure that you secure your social media account just like any other asset of the company.
And what I do with some clients is when we have sometimes the employee is setting up a particular social media account, and oftentimes those accounts need to be attached to somebody's name, but we make sure that we have that employee sign an acknowledgement that the account belongs to the company and turns it over. And that's really a lesson that's born from experience, because I've dealt with that situation of making demands on former employees and contractors, and even those who are just associated with the business that leave, former partners and so forth. And then they either, you can't get them to turn over the credentials because they refuse, or because they just simply decide not to do it, or they don't want to do it. So the easy way to avoid that is to make sure you have it documented as to who owns that material. All right, I'll take a little bit of this third section here where we're talking about healthcare ethics specifically in social media. And of course, the main concern is protected health information, security and privacy, and protection of that information. And really PHI is anything that relates to the health or condition of an individual that might identify that individual. It may be something as innocuous as an email address, or date of birth combined with some other information. Interesting. I like these factoids. If you take in a random zip code and I give you somebody's date of birth, their date of birth, whether they're male or female, and a zip code, on average, you will narrow down that the people who fit into that category to 2 people.
Really?
Yes,
wow.
2 people that have the same date of birth
wow.
on average in the same zip code. 4 people, 2 male, 2 female. So we're going to talk about this quite a bit, especially when we're talking about responding to patient complaints and reviews and so forth online. First issue, when we're engaged in any type of marketing or advertising activity for a healthcare business, like any other business, you want to be careful that any impressions that are provided are if you're giving an opinion, acknowledge whether it's the opinion of the individual or the opinion of the company. If it's the opinion of the individual, then you need to disclose your connection with the company, whether you're being paid or whether you're an employee or a contractor, and what your relationship is. Also, where there's industry relationships, we see this oftentimes with potentially with drug companies. There's all types of laws around this as well. If you have a relationship, if you've been paid to speak in the past on behalf, or if you've been invited to a seminar or some type of presentation, especially where your costs have been covered.
Mhm.
That needs to be disclosed when you are engaged in any type of online marketing or advertising activity.
Really, anything of value. I mean, you can be getting samples or
That's
whatever,
right.
and you have to disclose that.
So you really should just get into a habit. If whoever's speaking for the company really needs to be trained well in this. And the FTC publishes guidelines on the marketing and advertising. And again, refer back to this materials or contact these materials or contact us with respect to how it pertains to healthcare businesses in particular. Also, we see a lot of potential issues with employees when it comes to dealing with social media and online activity. Here's some actual examples of things that potentially carried over into social media that have happened, and photos that are tapes and photos of residents in assisted living facilities, patients. We'll talk also about patients sharing cameras and equipment that they can record each other. So these are the things that we want to try and avoid. Obviously, these are actual examples. This was this first one, the CNA charged with planning to tape sexual assaults. They were going to post those online. This was I found this under an HHS press release. And the second one, this worker who took the video, this was up in Kenosha, Wisconsin. So it's been a hotbed of activity since that the shooting and trial and so forth. So here's some do's and don'ts for your employees in when you're talking about what they should be and shouldn't be doing online. Obviously, don't make posts about any patients or we refer to residents in any type of assisted living facility. Avoid social media friendships unless you already have a pre-existing type relationship with or it's a relative or a friend, somebody you already. Also, if you're the healthcare employer, you need to understand that your employees' actions can get you in trouble as the employer through vicarious liability. So if you have somebody acting on your behalf and somebody else can show that that person was acting with your express or implied consent or acting at your behest online, those activities can trace back to the employer. And we see that all the time, where the employer is sued due to the actions of the employee, where individual owners of a business are sued because something happened with respect to an employee in the business. The law should provide some protections there against unreasonable extensions of vicarious liability, but you need to understand that it's a risk and something you have to deal with.
I think that's where having these policies in place, formal written policies about social media, those are all factors that would demonstrate that the employer took reasonable steps to train their employees. So another reason why it's a good thing to have them and enforce them.
That's a great point. And finally, this last point here, don't let this go on. Don't let this one go without some due attention. That happy patients, happy customers are less likely to complain on social media, less likely to complain to others, less likely to complain to state agencies, less likely to seek legal recourse. You can get in front of a lot of these problems by trying to address a small issue quickly and efficiently if you know that something's going on. So one, have properly trained employees, but two, if you realize that there's a problem with a patient or somebody that you serve, try and get in front of that problem. Because it's oftentimes not the problem that leads to the bigger problem. It's the problem in the fact that the business ignored it, and then they go online and they're airing their concerns there, or they're complaining to a state agency. You can avoid a lot of that with some good proactive behavior. Just some key components here. Maybe you want to mark this slide. These slides are being made available to everybody who's in attendance today, or if you like to share these or have questions, you want to reach out to us. But these are some key components that we've listed here that you want to have in a social media policy or an acceptable use policy. There are issues here that are particular to a healthcare facility, and right up at the top, have a reason in the policy. It could be that you want to maintain privacy and respect the confidentiality of patient and resident information, and also provide for a respectful environment between the folks that you serve and your employees, and among employees, staff, and supervisors. So maybe have a little policy statement in the beginning, and then consider some of these. These aren't all definites, but consider a restriction on smartphones and personal devices. Obviously, patient photos and videos can be a problem, but there's going to be exceptions too. So also be careful with, and I have this on the next slide, zero tolerance policies. You're going to have, because you have a policy against taking photos of patients, you may have judgment calls in here where you have somebody, a patient whose kids visit from far away, and they ask you to snap a family photo while they're all together. And it's nice to be able to use a little bit of judgment there. So I have a comment on the next slide here at the bottom. Just be careful with zero tolerance policies. The last slide were things that really should be in an acceptable use policy, or at least addressed or considered. This slide is more of the be nice, things you learned in kindergarten type slide. But it's not a bad idea to include these. Again, as Kathryn said, the more you make it clear to your employees and your staff what is expected of them when it comes to dealing with the new age of the internet, social media, and all of the avenues available to communicate with the world. If you provide some guidelines on what the expectations are, more likely you're going to be able to point to that later if somebody tries to look at you and say you did something wrong as a business, or that you failed to have a good policy in place to prevent bad activity as a business. So on this slide here, we asked the question, when can you discharge an employee for the violation of a social media policy or acceptable use policy? Obviously, if there's a HIPAA violation, a breach of confidential information, that would be fair grounds for termination. Of course, Florida is generally termination will state, so either party can terminate an employment relationship unless you have a written contract by just giving notice to the other party, although it's customary to give a certain amount of advance notice of termination, whether you're, especially for the employee. If you have a contract, then you look to the contract, and if you do have a written contract with your employees, you probably want to cover these issues in here, or you want to have some catch-all provision that says that failure to follow the reasonable rules, regulations, and policies of the healthcare business are grounds for termination. Typically, I would say, unless it's an egregious violation, or lying, theft, some type of crime, something that affects patient privacy or patient well-being. Other than that, for lesser type offenses, consider whether notice and some type of letter of reprimand or some type of documented correction and notice to the employee is warranted. And if you give them notice and they don't correct it, and then the same issue happens again, depending on the severity, if it's one time or two times, that's going to help you later. If you have to deal with some type of claim that you wrongfully discharged an employee for some reason, the more notice that you're able to give, oftentimes the better.
Agreed.
Yeah.
Agreed.
All right, this kind of gets into some fun issues. We did if anybody was able to join us a little while back, Kathryn and I did a seminar. It was more for general businesses, and we also talked about attorneys in dealing with online reviews. This has to be, this to me is like one of the most frustrating areas of practice on the internet, is dealing with online commentary and reviews, because as we'll see, anonymous commentary is generally protected. Websites that host and make available anonymous commentary are generally protected. I think that's gotten way out of hand, but this isn't my soapbox today. Well, I guess it is. It's our video, so I'll comment on that a little bit more. But we're going to try and give you some suggestions that'll help. First, take a look at this scenario here. This is a dental practice that was required to pay a fine to or pay money to settle claims that it disclosed sensitive patient information online. And this happened because they were responding to a social media review. So, what are you to do? You have somebody goes online, especially if the person makes it, semi-anonymous, and sometimes you're able to identify who the person is. A lot of businesses have suffered this. Somebody goes on Facebook, or they go on some review site and they post a negative review. It's not true, or it leaves out a bunch of facts, or it's a complete lie, or it's a competitor doing it. But if it's one of your patients and you know who they are, first thing you have to consider is, can I disclose the patient's information? And generally the answer to that's going to be no. You run the risk of getting yourself in trouble if there's an anonymous poster online And then you turn around and say, well, actually, we did dental work for this person because their teeth were all jacked up because they never brushed their teeth and they were crooked and they had summer teeth. And we fixed the problem, but the problem was so bad that we could only get them back to quasi-normal. And you get yourself into a lot of trouble for disclosing the personal information, although you can have fun doing it. And look at as Kathryn I pointed out earlier, have policies in place. So one of the things that caused additional that I think that exacerbated the problem for this dental practice in this particular issue is that they had no written policy and procedure in place for ensuring the protection of PHI in connection with any social media interactions. So if you have a policy in place, you say, look, we have a policy, we've talked to our employees, we've done training. If you have one rogue employee, as a business, you're less likely to be responsible for an employee that goes off the rails versus another business who just hasn't had any training or addressed these issues at all. And here, big issue at the top here is, again, we're going to keep pounding on this because, my understanding is that from any seminar or webinar or any type of presentation, generally you want people to take away 3 things. So the first 2 of these are going to be privacy and security of PHI. There is no exception for public disclosure of PHI in response to online complaints. So you've got the 3 disclosures: treatment, payment operations, and payment. Or treatment, healthcare operations, and payment. There's no exception that allows you to disclose PHI online, even if another patient opens that door. We don't have the concept like we have a law sometimes that, if one side opens the door, the other side's allowed to comment on it. You're still bound by all the requirements of HIPAA as a healthcare provider. You really don't want your employees, you don't want your healthcare providers at your clinic and you employ doctors, nurses, other types of providers. You really don't want them commenting. Better that nobody is commenting online other than somebody who's officially placed in a position to make comments for the business and is doing it with business approval. And again, if you look at the bottom here, for some of this, we've referred back to the AMA Code of Ethics. And AMA has specifically stated a physician should not post identifiable patient information online and should follow general ethics requirements for privacy and confidentiality when online. And as we'll see later, the AMA also recommends that physicians keep separate their personal and professional activities online, or if not, really understand how to adjust privacy and security settings to make sure that they are proper when they're acting online.
This is probably one of my most favorite slides in the whole deck.
There you go. We wrote it out for we wrote out 3 possible responses. So you say, okay, somebody's posted a negative review. You can pick the one that works for you. Which one's your favorite? You have one or a combination?
I think the takeaway is it all says take it offline and talk to us directly. But I think the last one is probably to me the most interesting because it allows you to kind of punch back without really punching back. We've got professional, as it says here. We're restrained by professionalism to, from publicly responding to these comments, even when those reviews contain misleading, unfair, inaccurate information. So you're not saying that the particular review specifically has that kind of information, but the inference is there. And I think that one you may want to pull out if it's a particularly nasty or inflammatory review or post.
So for those who are counting at home, or if you're following along, put a little flag on this slide, put a flag on the slide that gives you the information on what to put into your acceptable use policy, and you have a couple takeaways today. Right. And what we really want to do when somebody posts something negative online is flame the folks. I've been there, everybody's been there. I've had clients that have gone through it, but really what ends up happening, and the way the algorithms work is oftentimes on social media, the more comments there are, it drives the post up. So somebody posts a negative comment, if nobody responds, it hardly gets noticed. But if a negative comment gets posted online and then you respond and then the other person responds and then they have the brothers, I've seen it where all the family members start jumping in. And in one case we had somebody from Maryland just posted online, I wouldn't go to this business because they did my sister wrong down in Ocalacha, Florida. They've never even been to the business, and they tag everybody.
The sister's contacts get pulled in, and then it just kind of goes from there.
And then all of a sudden it goes viral. Let's avoid that from happening. this slide, this is a very divisive issue. The protections online available for online anonymous posting, the protections available for host website. Section 230 of the Communication Decency Act goes back to a 1997 origination, I think it was 1997, when Congress wanted a law to protect service providers and hosts on the internet who just hosted a platform. So the analogy would be, if I have a platform online, just an open blog forum where anybody can come post information, it wouldn't be much different than if I put a chalkboard outside or a poster board outside, or posted something up at my business, and I put, you see community boards up there, and if somebody comes up and posts something nasty or vulgar or offensive, we're not going to hold the business responsible because they had an open forum and somebody else came and posted something bad there. That's generally, in very basic layman's terms, how the Communications Decency Act was designed to work. It was to protect innocent hosts who allowed others to post information and not hold the hosts responsible for that information. I think that it's gone way off the rails over the last couple of years. I know there's lots of, and I go to some of these technology conferences and people are way on the other side. Section 2, you'll hear that the CDA is what makes the internet run because everybody's got immunity and protection. But I also think it's a huge problem when you have situations where either the host is acting as an editor, and that means that they're taking stuff that the host agrees with and leaving it posted and remove it. When they start removing some things, and so we're going to remove this because it's offensive, now they're becoming an editor. They're removing things, who's to determine what's offensive. Another problem is pushing good reviews high and bad reviews low. There's been allegations against companies like Yelp that they do that in order to sell Yelp. If you are an advertiser, if you want to improve your rating, the allegations have been that if you sign up and you pay a subscription, that Yelp will push all your positive ratings up, and if you leave, they'll push the negative ratings up. And then the other problem is with anonymity. A lot of people have a problem with anonymity. Candidly, if you go back even to the founding of the country, Alexander Hamilton wrote under Publius. The guys who wrote the Federalist Papers and commentary on the Constitution, and even before then, often wrote anonymously. And so anonymous, Ben Franklin, I believe, wrote under a few pseudonyms. Anonymous commentary goes back and is enmeshed in our history. The problem today is that when you have anonymous commentary that goes up, there used to be a website, I won't acknowledge the website because it was so vile. I think it's still online, but not nearly as popular. But there was a website where somebody could go post something negative and that information would stay there, even if they acknowledged that they had lied and posted the information and there was no truth to it. The website who posted the information, who was the host, would refuse to take it down. And people would try to get court orders and so forth. But then they also had their own dispute resolution process that you could pay for to get the information. So it really got abused. But in any event, what the takeaway here is that you are going to deal with anonymous posting. Yes, you can call me. There are ways. I have had success. We've dealt with that issue on limited circumstances. We've had success having material taken down. We've had success unmasking quasi-anonymous posters. But there is as much an art to it as law. The law is very protective of these companies. If you can prove actual defamation, you have a good chance of getting the information on who the poster is. But proving actual defamation, slander or libel, spoken or written, is very difficult because you really have to show factual statements or certainly show statements that are taken way out of context. And then create some type of libel through their implication, but libel by implication is very difficult to show as well. The other problem is, in order to do this, you normally have to file a lawsuit. The process, if you're dealing with an anonymous person, you say, well, who do you sue? Well, you oftentimes will sue a John or Jane Doe defendant. You may sue the hosting company in order, especially if there's some exceptions to the CDA. They're very narrow exceptions. They're tough to get into, but you can sometimes sue the hosting company. That's what we've done in the past. To get this information. Really, the goal is to take stuff down, but this is a commitment. That's a time commitment. It's expensive. If you get involved in a lawsuit, I have had folks that I've spoken to where there's commentary, and if it's not pure defamation, we don't want to address it, because now all of a sudden you're in a lawsuit that can really turn into a bigger problem than the initial commentary. So I always talk to clients when they want to go that direction, ask, what do we want to accomplish? What are we going to get out of it? Keep in mind also that people who post this kind of stuff online are often not the same type of people who have accumulated significant assets and wealth. So you're going to have any money at the end of the rainbow if you do sue them. Oftentimes the worst actors in these situations are the people who have nothing and have nothing to lose.
Going back to the anonymous posting, have you ever had a situation where there's actual bots or some kind of, something out there other than a living, breathing person that's pushing out these kind of anonymous reviews?
That's a great question. That's been alleged. Usually that's been in connection with positive reviews. So somebody, Amazon dealt with that for a while. Now there's more. I think Google does that as well. Google will allow you to challenge reviews if you think they're not legitimate. Amazon will allow you, or Amazon will go after reviews that they think are not legitimate. There's probably a tech way to do that, but no, personal experience, I've not seen anybody have success taking reviews down. The only time that I've had success or seen any success with it is when you are actually able to identify the person and you're able to compel the person and the company together to agree to take something down. And you usually have to have a hook. You have to have you have to have a way to go after them, or you have to have deep pockets. So we have clients who have vast resources who have decided to go after somebody, and we've had some success. But good question. I haven't dealt with the bot issue on the negative side. But that is, if you're wondering, by the way, folks who are wondering about reputation management, a lot of reputation management, that's what it boils down to. You got a negative review, you're not going to remove the negative review, so let's pump up your positive reviews. Understand that the FTC not only frowns upon, but has stated that it's deceptive to have false reviews. They call it astroturfing, putting up fake positive reviews. If you are having employees or others post reviews, they should disclose their relationship, or if their relationship is not obvious, for instance, if their name isn't in the business. But if you can get employees, or not employees, if you can get customers, patients, your people who have dealt with your business, other competitors who respect you, people who refer to you, and you can get those folks to post positive reviews, that's going to drive up your overall ranking. That's a lot of what the reputation management is about. Here's some other interesting quandaries. You're a physician provider for patients, and you see them engaging in dangerous behaviors online, or you have a client that you're counseling them on weight management, and you see them eating cheesecake all the time on their Facebook post. It puts you into a weird ethical situation. I think this is why, I'm not sure there's any right or wrong answers, but it's just one of these weird things that you deal with. If you're going to be friends with folks online, or you see them drinking alcohol excessively, it puts the professional in an interesting ethical situation. And you distinguish that from digital monitoring, where you have a pacemaker or a glucose monitor or something else that your provider, your professional provider, actually can see the results of. What we're talking about here is your social behaviors that now can influence your health, and how is the healthcare professional to respond to that or deal with that. I think it can be a very sticky situation.
I agree.
Little down the bottom here, have a go-to confidant. I like to do this with certain clients. I have clients who call me for questions that aren't necessarily legal questions, but we talk through some of these issues. It's nice to have somebody, a business advisor, practice advisor, just a close consultant, legal counsel, when these issues come up, just to kind of talk through it. And what ends up happening a lot of times in these talks is we get going back and forth, and we realize that the best action is no action, or we realize that the best action isn't identifiable right now. So say, let's sit on it for 24, 48 hours and come back to the issue and see if we really need to take any action at all. Here's some guidelines. I'm not going to read through the whole slide, but you can mark this slide as just general things that you want to be aware of when you're managing your healthcare brand online. Here's some additional, down the bottom here, these indented bullets. I referred to this earlier, where the AMA has recommended that professionals, physicians in particular, but I think this applies to a lot of professionals, really segregate your personal and business sectors on social media.
have any questions in the chat, or do you want to see before we move
You know,
on?
there are a few questions. Good. I'm glad you did that. So let's see. We've got, all right. Seminar materials. If you have questions, fire them away. No, actually, I think we've got, if you do have questions, you can address them now or at the end, and we'll have a couple minutes, it looks like, potentially, or afterwards, if you want to give us a call or set up something to go over any specific questions. So here's the next part. We're going to jump into advertising and promotions, endorsements, testimonials. A lot of this, while healthcare organizations do use the internet for promotion, advertising. We've talked about the review issues. When we're talking about advertising and promotions, we're usually going to be within the domain of the FTC guidance, as long as you're not disclosing personal information, protected health information, as long as we're not engaged in any activities to violate, Stark or kickback, which is a potential concern with any marketing. On your general advertising and promotion for your business, we're talking Federal Trade Commission guidance, but this is certainly applicable to the businesses that we're talking about today. So, first is, you can't post or provide information that's false or deceptive. And deceptive could be something that's not literally false, but is misleading. For instance, it omits, you may be, maybe your brother is a business owner, your brother's a dentist, and you think your brother is the greatest dentist of all time, and you post online, this is the greatest dentist ever. If you have your whole family, if you have 5 or 10 reviews and it's all family members posting about how great you are, you may want to have them disclose, like, hey, this is my brother, but I still think he's the best dentist ever. If you have employees doing it, they're on your payroll, you want to have them make that disclosure as well. And don't make your disclosures in like a light colored font that's 2-point. I love these. I don't listen to the radio very much, but I've heard advertisements sometimes if I happen to stumble upon something on what it is, Sirius or whoever does the radios, and there's some outrageous ad for a new car for $99, and then there's a guy talking. I swear there's nobody that can talk that fast and that long. The guy spews through 3 paragraphs, like 700 words of information in like 8 seconds. They had to speed it up, and it's like low. So you don't want to have disclosures that people can't find. When we write documents, if we're making a disclosure, we prefer to change the color, change the font, make it all caps, bold it, make it stand out so it's obvious that it's in there. And sometimes, depending on the circumstances, that might be required. In some legal context, certain disclosures, waivers of rights are required to be in some type of enhanced font.
Or have it right on top of a signature block. Sometimes it helps to.
That's right.
The argument that it's
people are signing
conspicuous
off
if people
on
are
something.
signing right underneath it.
And we mentioned this earlier as well. If you have a connection with the business, especially if you're considered, this is talking about sponsorships, and this is really dealing with any circumstances where you receive some type of compensation or reward for a business. If you're talking about that business online, especially in a professional context, you want to disclose, even if it means, they gave you free product, they provided you with a free hotel room or a free trip, or they reimbursed you, or they paid for your dinner. Better to disclose that. And you'll often see people, if they're making, talking about something they really believe in, say they haven't been compensated by business. I really believe in this particular business, but we don't get paid by that business. We don't, there's no compensation, but we just think this is the best group out there. If you really start looking into how businesses make money in affiliate marketing, promotions, endorsements, what do they call it now? Influencers, how influencers make money. If you go online and you Google what is the best of something, chances are all of your page 1 results, almost every line on that page is quite likely to receive some type of compensation in some way by making recommendations, and they're supposed to disclose that on their website. More businesses are doing that now in the last couple of years, but it's still a relatively new phenomenon. It doesn't mean you can't get honest information, but I think it certainly
Skews it a little bit.
skews how you interpret that information when you know that the people have been paid. Some hashtags, all of this is, I'm not a big user of hashtags, candidly, but these are some ideas. And as we said earlier, the FTC will crack down on false or misleading or deceptive advertising, and other folks who can do that are your competitors. If you are making false or even misleading statements that cannot be substantiated, and a competitor decides they want to come after you, they may have grounds to come after you for unfair advertising. I've dealt with those claims as well. They are often mushy and can be a big problem for both the business that makes, if a business gets to the point that they're going to file that lawsuit, and a business responding to the lawsuit. And just like vicarious liability, if somebody is out there promoting your brand and you know about it, and you don't make sure that they're making correct statements and making proper disclosures, you, the advertiser, can potentially be on the hook for their activities. Vicarious liability can relate to not only to employees, but the contractors, and especially if you know that the activity is going on and you don't do something to stop it or correct it. Now, that being said, the FTC does recognize, and courts will recognize, that sometimes a company has little or no control over the comments that others make online. That comes back to the section 230 concept, and the idea that people can post anything online, and it may not necessarily be posted by the business. But you have to, if you're dealing with an endorser, if you're dealing with somebody that you are actually compensating in some way through free product or services or money, and they are making representations online, you want to make sure that they are making true representations. And you may want to tie any compensation you have to that, to not only them making true representations, but also have some indemnity type language in your contract with any promoters or sponsors for online activities. So anybody who's doing business and representing your brand online has to do so properly and honestly. And if they don't, and there's trouble caused by that, they are required to indemnify you. In other words, pay your costs for dealing with the information. Here's an example of an ad. This comes actually directly from the FTC. And again, she's making a representation here, about shooting a movie scene and losing weight and thanking, fat away pills for making it easy. What needs to also be in this, and the other problem we have here with, as well as with Twitter and other social media sites, people are looking for short, quick bits of information, but having another hashtag, promotion, promoter, influencer, paid, had to lose, you could try, and we understand that people are also trying to sell product oftentimes, right? So you could say, had to lose 30 pounds, thanks Fat Away Pills for making it easy. Although I received these for free, I only make endorsements or representations if I truly believe in the product, something of that nature. All right, best practices. We're going to come into our last few minutes. I want to make sure we do our hypotheticals. But you should, anybody who's getting paid for endorsements or for advertising online should be familiar. In fact, they should be the one counseling you on a lot of these requirements. If you're dealing with somebody and they have no clue that they have certain disclosure requirements to deal with online, you probably want to search out somebody else. At this point, if you're a paid endorser or a paid influencer, you should be aware of the guidelines. There's a wealth of information available on the FTC website. And then, if you have any questions, if you're going to enter into a contractual arrangement with somebody, you probably want to have legal counsel look at that. And you also, again, there's oftentimes there can be depending on what the relationship is, you can have a kickback concern that would affect healthcare businesses. That's an unusual issue. It doesn't affect other businesses, but if you're receiving remuneration for the referral of patients, you want to make sure that there are exceptions. You want to make sure that your activities fit within one of those exceptions so that you don't have a kickback issue. And we have that both under state and federal law. All right, we've got two hypotheticals. Here's the first one. A public relations agency hired by a plastic surgery center asks employees to pose as ordinary consumers and post reviews on Facebook without stating the reviews are made by employees. At this point in the seminar, you should be able to answer this question, whether the public relations agency, the surgery center, or both could be charged with deceptive advertising practices. Kathryn?
Say both.
And we need to do a vote online here, but I'll give you a second to write down your answer. And the answer is yes, both. The fact that the testimonials are made by employees, the employees should have disclosed their connection to the business and to the public relations agency, and the failure to disclose those relationships can be considered a deceptive act by the FTC, which can result in an action being brought by the FTC or an action being brought by a competitor. We have a couple slides about contests and sweepstakes.
Yeah.
We've had healthcare businesses come to us and say, oh, we want to do a contest. I know it was one in particular.
You want to give away X or Y, and there's some people think of it as just something for fun, but you have to keep in mind if you're sponsoring these kind of sweepstakes, so each state has laws that regulate lotteries and other games of chance. And so if you're only opening it up to, if you have a small practice, you're opening it up to an area within one state, that may be more manageable to research and kind of vet. But if you are doing a national contest or sweepstakes, that's going to be much more of an undertaking. So you have to really decide, is it really worth it? I mean, this is the benefit of doing this kind of promotional activity going to outweigh the cost and the potential risk of doing it incorrectly?
These are tough. I would say if you're looking at doing a contest or promotion, if you're a healthcare business or any business, even for a not-for-profit business, there's still a lot of legal requirements. And if you're a for-profit business engaged in this type of activity, you really need to be working with legal counsel and with a group who really understands that area and guides you properly. User-generated content. Most healthcare businesses are not going to have user-generated content on their own sites. But if you do understand that, if people are posting stuff on your website, I mentioned Section 230 often earlier, I mentioned it a few times, that protects hosts, but it can be different if these are employees or patients of yours that you've specifically invited to post. There are, as I mentioned earlier, exceptions in certain ways that you can get in trouble. One of the big ones for Section 230 is intellectual property. If somebody shares information about a competitor or any other business, or if you can shape the information as though that information was solicited by you as the business and it was used by you for profit, that can be, it can take it outside of those exceptions. But I don't think if you're going to have user-generated content, one thing you definitely have to have is not only an acceptable use policy for your employees, but an acceptable use policy for anybody who's posting information on any site that you control. If you need an acceptable use policy for those purposes, contact us, because those really need to be tailored specifically for the type of activity you're engaged in. More on the user-generated content. Again, if somebody posts something that violates somebody else's intellectual property rights or constitutes false advertising, you as a business can get in trouble for that. Some best practices. This is a big one here. Required to be original content and true content. That's really what it is. Make sure it's original, true, and make sure that anybody who posts information on your site is posting only factual information that they have personal knowledge of, and it's not related to third parties. And again, keep in mind the HIPAA and PHI requirements. My mouse went out, pardon me. Here, I gotta bounce back. All right. Here's our second hypothetical as we come into the question phase of our seminar. An orthodontist invites patients as part of a promotional contest to post videos to its social media accounts that illustrate why its braces are superior to those of its competitor. Could the orthodontist be sued for content included in the videos posted by the patients?
I think it goes back to false or misleading, right? If it's true and it's made in good faith, I think the risk is low. But if what's being posted is misleading or infringing or anything that we talked about in the past that creates exposure, then I think the orthodontist, even though they may have only the best intentions, could open themselves up to liability.
And that's pretty much the exact answer. That's the essay complete, proper answer. Hopefully you got it right watching at home. And who's going to sue them? It's generally going to be a competitor. You know, FTC isn't generally watching an individual orthodontist. There's no other regulatory agency that's watching activity on the internet generally, with minor exceptions. But generally, this, you know, what it's going to be is a competitor who says, "Hey, your braces are the same as my braces. You have no way that you can quantify the fact that one is better than the others. And if you make any claims that are misleading, as Kathryn said, it could lead to problems. You could also get into trouble if you infringe on your competitor's intellectual property. And it may be something as simple as posting your competitor's logo or some information online. And businesses do that. It's a strategic thing for businesses to take the competitors, throw their name and logo on their own website for comparison purposes, because they know that the search engines, when somebody's searching for XYZ business, will pick up the ABC business with XYZ's name and logo on their own website, and then they generate more traffic, and they click on the website and they show up, and then they see this negative review, especially these ones that don't make it immediately evident that the business that's hosting the website is a competitor. And then they have this negative, you know, be careful of so-and-so's product. I had a client that happened. You know, you click on the website, you get to the website, you say, be careful before you buy this product. Here's things you understand. And then they try to, you need to understand. And then they try to sell you something else. We filed a lawsuit over that. That was a business where we actually filed a lawsuit because it was so prevalent and it was so misleading that we couldn't let that go untouched. So that's the type of stuff that can get in the lawsuits. With that, we are at our hour's time frame. Any questions, answers, we'll look in the chat box here again. And if you have something beside or you know, beyond today where you need further clarification on something, or if you have questions, anything about the slides in general, or anything related to this topic, or anything in, you know, healthcare or business, feel free to reach out to us, and we will try to be the best resource we can be for you. And with that, have a great rest of your day. Thanks for joining us, and we'll see you again soon.
Bye-bye.
Bye-bye.